Okay, so we talked about criminal offenses, right? We talked about what made a crime. We established that there are different levels. There's stuff that happens to the person, to the property, and there are other offenses: drug possession, fraud. Okay, or some of the other ones. Now we'll talk about the actual criminal court system. How do you go through it? What is the actual system? So basically, it's how criminal court system is structured, who is involved in the system, and what are their roles, what are the key aspects of the criminal process, and what are the rules of evidence. So when you look at our criminal court system shares a lot with the English court system, right? It doesn't look at the American one. The American one has a different look and feel because they've adjusted it a bit. Our system is reminiscent of the English one because of our connection to the Commonwealth. So if you want to break down what the courts look like, this is sort of the map of what a court system looks like, right? So remember, we talked about the fact that while the federal law creates the criminal code, it's the provinces that do the day-to-day operation and the actual enforcement of the courts, right? So in provincial courts, you have four distinctions. Criminal court deals with crimes. Youth Justice Court deals with youth, so that means anything that deals with youth, which is anyone 17 years or younger, you commit a crime, you go there, unless you are tried as an adult. Then you go to the criminal court. Family court deals with, again, all issues dealing with family, so marriage, the custody, divorce. And small claims court is sort of the civil court. We talked about the fact that if you get charged with, if let's say Thomas steals something from a store and gets charged and he gets sued, he goes to small claims court, right? So basically those courts are in charge of making sure, of running the process. If there is an appeal, which means if there is a mistake in the procedure or there is something that the defense can say this was not carried out properly, you go to the Superior Court of the Province and Appeals Division. That's where there's, I think, 3 judges that hear your case and make the decision on whether or not there is a matters for your case to be thrown out or.
Sorry, well,
no problem.
You don't know where exactly
Computer lab.
Computer lab, thank you.
No problem. Where you can be thrown out, the case is thrown out and either are for retrial. If they agree with the decision of the lower court, it stands. And if the people still want to appeal, they can go to the Supreme Court of Canada, which hears those court cases. Now, remember, the Supreme Court of Canada can choose not to hear a case at all. They can say, well, we're not hearing it because they only have a limited amount of cases they hear per year. And again, it takes sometimes weeks or months for them to come with a decision. Right? And again, those for crimes. You also have a federal court, which is a trial division of Canada. So when federal laws are sort of been violated, you can go there. They have a separate appeals court, and they have the Supreme Court of Canada, right? There's the Superior Court of the Province, which is a trial division. So again, this is where sort of indictable offenses go to. Okay, so if you have a crime, those are the things that you would go to court first, right? The criminal court here, the provincial courts sort of feed up to here, but also this is sort of smaller. This would be summary offenses you deal with crimes here. So in all crimes, what you have to do are things, it's something called a preliminary hearing, right? The judicial inquiry to determine whether there's not sufficient evidence to put the accused or person on trial. So when you get arrested, right? And you can read about arrested, like the police place you under arrest, charge you with a crime, and then they have enough evidence to gather with say that you've been not only have I arrested you, but I have enough evidence to proceed to charge you with a crime, and you're going to go before a judge or go to the criminal justice system. The first thing you have is a preliminary hearing, and what the judge looks at all the evidence available to make sure that there's a violation of the criminal code, that the courts can actually there is enough evidence to proceed further, right? If there's not enough evidence, you get booted out. If there is evidence, you go through the next stage, right? So The Superior Court of Province is the highest criminal and civil court, consisting of a trial division and an appellate division. So again, your crime can go there. If you go to that Supreme that court, that's where you would hear the decision. So every province has its own superior court, and certain crimes are difficult to that. So if you look at this chart, again, I'm going to go through it bit by bit, but I'm just going to show you how each one of those ones work, right? So basically, summary offenses go straight to trial and provincial court criminal division, which means these are minor offenses, things that are less than 2 years in prison, or I think less than $5,000 for a fine. For indictable offenses, there is a whole different section, which means that it determines what happens where you go. If you commit this section in the criminal code, you go to trial of provincial court criminal division, and these are all for serious indictable offenses. If it's sections of 554 offenses, you have a choice of different things. You have provincial court judge, trial of provincial court. You can also choose, if you're one of these offenses, judge alone, judge and jury, right? Judge alone, judge and jury just depends on what you want to decide. Some people want to have just a judge because the judge will, you figure, if it's just a technical issue, a judge tend to be trained to be impartial, and maybe you will be able to, it's just a matter of just convincing that judge. Some people would argue for a judge and jury because the jury is, you get your peers, you figure that maybe people aren't going to accuse you or think you're going to get a crime, you might be able to be more successful. Juries do make decisions, but remember, juries are bound by law, and in an actual criminal court, they spend anywhere from a day, 2 days of just instructing the jury, right? So the Crown would go to the jury and tell them their case, like the closing arguments. Then the defense would talk about their case, and then the judge would sit down and say, here's what is at stake. Here is the violation of the law. Here's what you should decide based upon this evidence so far. You can account for this specific evidence. This evidence cannot be accounted in your decision, right? So if you ever see an actual court case, they will spend days just instructing the jury about what to do before they even make a decision. So for these two types of courts, you have a preliminary hearing, which means, again, you determine whether or not you have evidence to proceed. If you do, you go forward. Trial and superior court, judge alone, trial and superior court, judge and jury. All right. For sections 469 offenses, you have preliminary hearing, provincial court, criminal trial, and then you go to superior court and judge and jury. So it simply means that there's going to be some laws that they say, because of the nature, you go to this system, right? And it's totally arbitrary to those laws or those violations found in these sections. So the Federal Court of Canada, the court will hear with jurisdiction to hear civil and criminal cases referred to by federal boards, commissions, or tribunals, and to rule on constitutional issues referred to by the jury general. So federal court deals with, let's say, criminal cases that deal with like aspects of the federal government, right? Commissions or tribunals, and anything the attorney general says it goes there. The Supreme Court of Canada is the highest law of the land, and basically you go there to criminal court cases go there because there was either a violation of the individual's rights in the court trial, or there was a mistake in law, and they're the final say, right? They also deal with constitutional questions that the government directs towards it, but here, remember, not all cases go before the Supreme Court of Canada. I can't remember the number, but it's not that many they hear per year. And they have like a recess or a break because if I'm going to go before the Supreme Court of Canada, I make several days of me providing evidence to argue for the Supreme Court to move to my decision. And then it takes several days or weeks for those lawyers to look at the law, to examine it, to have a discussion, and then to vote on what the decision is, right? Then after that, when they make a decision, they usually choose one judge to write the reason why they decided that decision, and then they choose another judge to write the counter argument. So it's like a 5-4 decision. The one will write, this is the reason why we chose, and then the one judge will write, this is the reasons why we're against that decision. And if it doesn't matter what the decision is, there's always a judge who explains the rationale of why they made the decision. You can look at the other courts, but there's a tax court and it deals with income tax matters that you have to go through. Malta Court of Appeal. There's a court martial of the armed forces. Again, this is sort of different. So if you're in the military, you go to a totally different legal system because your certain rights as a military officer are different than the ones for citizens, right? I think you necessarily don't have a right to remain silent as a military officer. The tribunal, there is no, I don't think in some cases there is no jury, but it's a separate legal system that you have to go through. Okay, so when talking about the actual court case, you have participants. The biggest thing you need to know about the court system is this concept, beyond a reasonable doubt. You might have heard it on watching television shows or watching anything to do with law, or hear about it. If anyone you know has gone through the legal process, does anyone know what the term beyond a reasonable doubt means? It's a big part of our legal system. It doesn't work. Our criminal system does not work without understanding that concept. Beyond a reasonable doubt.
It basically means that this is it's for indisputable doubt. It means that this was what happened. This piece of evidence is believable within sort of reality, right?
Right. So you've got a standard of proof hereby a defendant's guilt must be proven to the extent that a reasonable person will have no choice but to conclude the defendant indeed committed the offense. So reasonable doubt. Is there something called no doubt? No. There's no concept of this is, you know, for 100%. So even if someone goes on trial for a crime, we don't know for 100, unless there's a video evidence that we saw, or we were there and actually saw the crime, we don't know 100% what went down, right? So you're gonna have some doubts. But they said if it's beyond a reasonable amount of doubt, which means a reasonable amount of maybe didn't do it, then you have to find the person guilty. That's a reasonable person, right? I can go and say, look, I don't think the person did it, but, or I can say in a court case where I can say, look, I think that Nathan might have done the crime, but I don't have enough evidence to prove it, so I should let him go. The concept also implies the idea that we should side with the defendant over the state, right? There's an old saying that says, better that 10 guilty people go free than one innocent person goes to jail. Now, that's not the reality of the situation, of course. There are times where innocent people go to jail all the time. But the idea is that we rig the system of the, not rig, we design the system so that people, the individual has more protection than the state. Because simply put, the state or the government can have infinite resources, right? If I think Helen committed a crime and I'm the crown attorney, which is the prosecution for the state, I have a police service that can look into her. I have access to labs that can do forensic information. I can hire accountants to go through our finances, right? I can do a bunch of different things that as a state, I have the power to investigate Helen, right? Helen, unless she's wealthy, doesn't really have access to those things, right? She can't hire investigators to go over what she can do the crime. She can't necessarily go to labs to provide evidence to prove it. She can't hire experts to do that. I can do the state. So we try to put the onus on the state to prove the guilt of the defendant versus the other way around. Now, if you're wealthy and have money, it's a different game. Because if you're wealthy, yes, you can hire a really good lawyer. Yes, you can hire, hello? You can hire a private investigator. You can hire scientists. You can hire experts to argue your point. So, but most people cannot, so therefore we move to the system. Okay, so that's pretty much what the court looks like for Canada. Does anyone see anything that's a little different than what they think they would see in an actual court? When you look at the, is there anything that surprises people that they think, hey, this is not like what I think a court trial looks like?
Where the accused is sitting.
Yeah, well, that, I think that's just a railing, so,
Oh, sorry.
okay. Then Ryan said something about the accused where the accused is sitting, right? Who said, Ryan, did you ask about the accused?
Yeah.
Yeah, so when we see American legal systems and legal cases, you see the person sitting beside their lawyer, right? In the Canadian system, like the British system, the accused sits in the accused box or the defendant's box, right? Which means they sit separate from their attorney. Okay. There would be a security guard or a bailiff or someone there beside them, but they sit there separately. This is how the English system works as well. And you have the crown attorney on one side and defense attorney on one side. The crown means because we still are technically part of the Commonwealth, the crown represents the state, right? When you look at criminal cases, this is R versus Leakoff, right? R means Regina, which means queen, right? If we had a male king, it'd be Rex, I think, which means king, right? So the idea is that the crown represents the state, right? You have the court recorder, court clerk, judge, witness stand, and then of course you have the jury. So it's a little different, but we do keep the accused separate from their defense attorney, right? They talk, the defense attorney does present evidence, right? The accused doesn't really say anything because they would have talked and come up with a strategy and talked about what they're going to do. Again, when we think of court cases, it's not going to be like when I was a kid, but I used to love watching Law and Order. And again, those lawyers would get up and ask ridiculous questions and walk up to the person and call someone like a whore and say, objection, what's wrong? That's not how these cases actually work in actual court cases. There's opening statements that take anywhere from a day to 2 days to do for either side. Then they ask a series of questions, right? Again, intense questions. Again, those questions that take days. They're not overly combative because the lawyers are looking for evidence to point the point. And again, good lawyers ask questions they already know the answers to. So if I'm questioning somebody, I know I pretty much know what they're going to say, and I ask questions in order to get the information I need because I want the jury to hear it and I want the judge to hear it. I also want it on court recorder, right? Sometimes, I don't know if they still haven't been in court in a while, but sometimes you see a court recorder and they'll have something over their face. It's because they're kind of speaking into something, right? So instead of typing, right, that was shorthand or on the device that doesn't really look like anything, but you can think. Nowadays, they may have it over their hand and they just basically record and talk into what's being said. I'm sure if you, right now, the way we live in the digital world, I wouldn't be surprised if someone had just basically a digital recorder as a court recorder that they hook up and it just plays, right? So the judge is the official appointed to try the cases and in the court of law and to sentence the convicted person. The judge is supposed to remain neutral. They're the referee. They're making sure the laws are being observed. They're the ones that make sure the court proceedings go on pace. If either side asks an inappropriate question, the judge is there to determine whether or not they can or cannot, right? Right. So if I say, Thomas, how stupid do you think you are? In a court case, someone goes, objection, that's relevance of that question. The judge says, yeah, it's irrelevant. Move on, right? Asked and answered, right? It could be, Thomas, I want you to do this thing. Nope. And the judge goes, nope, we talked about this in preliminary hearing. That evidence would, if Thomas answers that question, it violates his Section 7 rights of the charter. Judge goes, we agreed you can't do that, right? I bring up this evidence to prove something. Your Honor, that evidence has been tampered with within the procedures of something. The judge makes the call. So the judge is there to make the call, interpret the law, and to make sure the proceedings run fairly. As a justice of the peace is a court official who has less authority than a judge, but can issue warrants and perform some judicial functions, right? So if I'm a police officer and I want to arrest Nate, I may go to Justice of Peace to get a warrant, right? I go to like, yeah, Nate's been selling drugs out of his house. I've got evidence from that. I've got witness accounts of them happening. I've got all this stuff. I want a warrant to enter his house. Okay, enter his house. You can search here, you can search here, but not there, right? So that's where you go to the Justice of Peace, and their job is to do that. For the defense, you're the accused or the defendant in the criminal court. You're charged with committing an offense, and you have duty counsel is a lawyer in the courtroom or police station to give free legal advice to a person just arrested before brought to a court. So there's two types of lawyers, right? Helen gets arrested for speeding. Let's begin drunk driving, right? She goes in, there's a duty counsel there who Helen is like freaking out. And duty counsel goes, hi, I'm a duty counsel lawyer. Shut your mouth and say nothing. Right? What happened, right? And anything that she tells that duty counsel lawyer is protected, right? Because they're there just to help you navigate through the system until you can get an actual lawyer. Your defense counsel is a lawyer who defends the accused person on trial. Those are the individuals who are experts in the law, and they will tell you what to do. Now, a defense counsel they're supposed to help you navigate the law, right? They work for you, but they're going to give you the best advice. So it is perfectly rational and reasonable that if you did something wrong and the defense counsel thinks they cannot win, they'll tell you to take a deal. Regina drove a car into a building and got out of the car and stabbed 3 people. Regina, they have you on tape. Regina, you made a digital recording about how you're going to go in there and stab a bunch of people. They got you. But I think I can get you down to, instead of aggravated assault, I can get you down to reckless endangerment, and I can get you down to assault 2, not assault 3. So I can get you down to bodily harm, not aggravated, and then you'll do 4 years instead of 20, right? Regina would say, that sucks. She goes, I know. If you want, we can go to court. We'll probably lose. So her defense lawyer sort of, he goes, no, okay, I'll take your advice. We'll go. So the job is to not necessarily to get you off, but to tell you what happens. Now, you at any time could say, no, I want to go to court. No, I want to do this. Okay, we'll go. You're paying the bill. I don't care. But they're there to tell you what you can and can't do. And again, most cases in criminal court, about 90+% are settled out of court, which means people sit down with the crown attorney and say, look, she was having a bad day, she lost control, blah, 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 blah. The crown's like, okay, well, what are you offering? Give her like reckless endangerment and thing to do 3 years. No, that's not good enough. I want to do 10. How if she does 5? Deal. And you gotta move on, right? So again, the same idea we talked about with champions, their job is to defend you, right? The crown or counsel or prosecutor is a lawyer representing the government responsible for instituting legal procedures against the accused. So their job is to persecute you or to represent the state in the matter, right? Now, technically, while defense lawyers are designed to protect you, the crown's job is to both defend the state and also to seek justice, right? Which means their job is to make sure that you serve that sentence, but their job is also to make sure the system goes through things. So if I know as a crown lawyer, Virginia's getting framed for committing a crime that Helen committed, as a crown attorney, I'm not really supposed to go after Regina, right? I may tell Regina, like, hey, turn on Helen and you get to go free. But if you don't do that, then all evidence I have is against you, and I don't want to prosecute you, but I have to prosecute somebody. So their job is to do kind of 2 things: represent the state, but they're also supposed to represent even the defendant, right? If I haven't done anything, right, then I shouldn't be charged with a crime, right? They bring forth evidence, which is evidence to prove or disprove the elements of an offense, right? So a crown attorney will say, look, Helen, we're going to charge Helen for second-degree murder. We have the weapon, and when we took her in, we took her fingerprints, because when we arrest somebody, we take their fingerprints. the fingerprints match with the weapon. We have a witness that puts her in the vicinity of the time. We have CCTV that shows that she walked into the building and then walked out after the murder. We even were able to get a warrant for a phone, and we tracked the was her Apple phone locator. We know she was in the building at the time. I have all this evidence, right? And again, the idea is that I gather evidence to say this is why I'm prosecuting. A crime attorney can decide whether or not to prosecute a crime or not, or to charge someone based upon the evidence presented to them, right? If they think they're going to win, if they think they have evidence to proceed to a crime, they will do it. If not, they'll say, I've got nothing. It doesn't make any sense. I don't have enough evidence. Court clerk is a court official who assists the judge. The court reporter is the person who records everything said during the court trial. And a transcript is a typed recorded record of everything that's said during the trial, right? Because sometimes during when jurors have to hear, they're asked to, they'll say, hey, can we hear that piece again? Can we hear that information again? And then throw it back to them, right? You've all heard that saying, anything said in the court of law can be held against, anything you said can be held against in the court of law. So if you say something in a court of law, like, yeah, I killed that person, I'm glad, that can be used. You can say, no, I wasn't joking. I was joking. Like, yeah, but you said it, right? The court security officer is there for security of the room. There's a sheriff, summons and pays and secludes guards and jurors, and the plaintiff assists the sheriff, right? Yeah, witnesses, right? Which means people are asked if they're there. Witnesses are people who might have observed or have information about the event. They are. The defense issue may issue a subpoena, which means you have to come and testify, right? If you don't, you are fined. Now, with that case, as you testify, you can testify what you saw, but you're not obligated to testify about anything that incriminates you. So, if I'm going to pick on Nathan again, if Nathan saw Helen kill Regina, but at that time Nathan was robbing a bank, and I said, Nathan, what were you doing that night? Nathan would say, I can't say because that's going to incriminate me. You can't say anything, right? Now, if Nathan was if I was a good lawyer, I'd say, Nathan, I'll get you an immunity deal for what you did. I'm not going to charge you, but you have to testify, okay? But you don't have to you can't be forced to be a witness and incriminate yourself. Also, remember that if you are brought to court, you must tell the truth. If you do not, or make false statements, you'll be charged with perjury, and again, you get up to 14 years. Again, I don't know many people who, perjury doesn't really get charged because most people just tell the truth, right? Or if you think it's going to incriminate yourself, you say nothing, right? The jury is 12 people who are supposed to be peers from a community. They can't have expertise in law, so lawyers, police officers, they can't be court officers, can't be part of a jury. They're meant to make a decision. Criminal cases are unanimous. It's either all 12 say you're guilty or all 12 say you're not. If it's split in any way, form, or fashion, 11 to 1, 6 to 6, 8 to 4, it's called a hung jury and a mistrial, and then you do it all over again. So there has to be unanimous decision. Again, for court cases, it has to be unanimous. Civil cases, I think you can split it, but because court cases and crimes may talk about depriving your freedom and your mobility, and you might be charged with a crime that follows you around, or the consequences of that crime that follows you around in a record for the rest of your life, it has to be 12 people who are not biased, who say you did something. To be a jury, you be 18 years old, gotta be able to vote. So who's 18 here? Anyone 18? No. Okay. He's 18. So Regina, you might get something in the mail. You might get something to vote. I got something recently that said, hey, you may have to go do a jury duty. I'm not being called to jury duty, but they're merely saying that you need to respond to this because we may call you on jury duty. If I don't, and I avoid jury duty, I can be charged with a crime, right? Then there's something called jury selection, what means I'm brought in with a bunch of other people and they get to choose. So the Crown and the defense get to choose the jury, right? And they need to determine who's going to be on the jury. You kind of want to choose people who are going to probably go your way, and you want to try to avoid people who are going to be biased against you. So basically, the names of the people in the jury panel are written on cards and put into a box that's selected at random. The names are read out loud in the court. So it's, well, daddy, damn it, I'm being charged. Person whose name is being chosen goes to the front of the court and faces the accused. Either the Crown or defense may object to the potential juror by challenging the individual. So there are different types of challenges, right? So Nate is going for jury duty, comes up, and there's several types of challenges. There's challenge for cause, which means the right for the Crown or the defense to exclude someone from a jury for a particular reason. I ask a question. Nathan, how do you feel about women? He goes, I can't stand them, they all should die. I could say, I don't want them on my jury because I'm an offense and I'm defending Regina, right? Prosecutor could say, well, I actually want them on my jury, right? So each side gets a certain number of challenges for a cause, which means a certain number they says, they can challenge for, they can say, here's the reason, here's why I think they're going to be unbiased. I can challenge that. Preemptory challenge is the right for the Crown or the defense to exclude someone without a particular providing a reason is limited ones of those ones, right? They can look at someone, nope, not him. Why? Preemptory challenge, I'm not going to tell you. Now, sometimes the people will do this because they think that they don't want a certain type of gender or race or group of people on a jury because they think they're going to go a certain way, right? There's a whole science to it. There's a television show, but there are people whose job is to profile jurors and tell you which ones are going to go the way because, again, checking a jury is going to determine whether or not you're guilty or innocence, the severity of your crime. So you're going to want to choose people who are going to support your position. So I think challenge for cause, I think you can always challenge for cause if you can establish a pre-existing bias. Either way, predatory challenges, you have a limited number, right? So some people will save those ones to target people they can't necessarily target legally, right? If a black guy commits a crime and I'm a prosecutor, I may not want to have black people on the crime, on the juror, right? Based upon, well, they're not going to avoid whatever, right? And I'll just use my preemptory challenges. But since I only have a limited number of them, I need to have 12 people on the juror plus 12 alternates. You pick and choose the ones you want, right? Because reasons are harder to prove. Preemptory challenges are easy. Okay? And then you don't want the juror, because again, the defendant could say, well, wait a minute, the Crown has eliminated every black person that for preemptory challenge they came up. That's clearly some bias going on there, right? And we have to start all over again, right? So then 12 jurors take the jury. So then when they go through this process and let's say they whittle down, so it could be a room full of people. I've never done jury duty, but I've heard, people spending days there where you have to go, you miss work, you don't get paid, you get paid some ridiculous penance. And they may have a room of 300 people that goes down to like 48. And then if they get their 12 plus 12 alternates, they do the juror's oath, right? I swear to well and truly do the true deliverance make between sovereign lady and the queen, the accused at the bar, whom I have the charge, and true verdict give according to the evidence, so help me God. So they're basically saying, I will judge according to evidence and not bias. Now, the problem is, and reality is, that's not necessarily true. Jurors can be biased. There's this old movie that we always show in last class, we don't have time, called 12 Angry Men, and it's set in America. And basically the movie set in a room where this kid is committed a crime, and everyone's saying, let's just do this. It's gonna be easy, it's gonna be quick. And the one guy says, well, this doesn't make sense to me. Some things are off, right? Now, each of the jurors want to get it done quickly. One guy wants to go to a baseball game. One person hates poor people. One person is angry at his son, and therefore is taking it out because the kid reminds him of his son. So you see that there's different biases that people have, and they swing. But the one guy's able to swing the jury from like 1 to 11 to his side, and each one has to face their evidence and whatever. And then basically he says, well, let's go over the evidence, and you find out, like, the person said this, but could that happen? And the guy who was doubting it says, hey, I don't know if they did it, but I have a lot of doubts, and these doubts means I cannot send the person away. It's a really good movie that usually, it's dated, but it's a good movie because it does talk about the fact that juror bias exists, and it is easier to hide right now, right? And sometimes juror pressure, right? If we're all in a room, let's say we're all jurors, and we want to say guilty, want to get out of here. It's Raptors are playing tonight. We want to watch the game, and Nate keeps on saying no, 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 no. I'm not. I don't want to. We put pressure on Nate. Like, come on, man. You want to? Here's the evidence. What are you doing? Let's just go. He's guilty. Let's get out of here, right? And sometimes people falter, right? Because even if, let's say, we all decide and it's 11 to 1, and we say we're stuck, the judge could say, you know what, go back in there and keep working on it until you come to a unanimous decision. Right? You're not deadlocked yet. Give me some more time. Sometimes jurors say, we're deadlocked, we can't move any further. Judge will say, well, I want you to spend more time waiting on it. Okay? I'm going to go through this. This is just a procedural process, but the only important things I want to talk about is burden of proof. The Crowns must prove your guilt. You are innocent until proven guilty. You don't have to prove anything. Good lawyers would tell you, a good defense lawyer would tell you to shut your mouth and say nothing at trial. Don't say anything. Don't bond until if you have to give a statement or witness a thing, you're kind of in it, right? Don't say anything. It's the Crown has to prove your guilt. You don't do anything else, right? So I know it's dramatic. We think about why didn't that person take the stand? Most lawyers say, don't take the stand. Don't say anything. Let them prove that you did something wrong, right? And even then, let experts tell us why that proof is wrong. So Crown makes the opening statements, right? They explain what the crime is, what they think the person did, how they're going to prove it, what's going to happen, how they're moving forward. Then they have witness examination. So the direct examination is cross-examination. Direct examination means that the Crown gets to question the witness directly, ask questions, determine if the person observed the crime, right? Cross-examination is when the witness is cross-examined by the defense, right? To poke holes in the story. Now, when you are having direct examination, you can't ask leading questions. Leading questions are questions that are designed to have a yes or no answer. Helen, did you go to the store and see that, on Tuesday, did you go to the store and see that Nathan was punching an old homeless guy in the face? It's a leading question, right? Now I'll do that. I can say, Helen, what did you see on Tuesday, September the 21st? Then you tell your story, right? Cross-examination, I can't do leading questions because I want to get, so you said he did that, right? Well, how do you know, right? That's more direct. But direct examination, there are no leading questions. I have to ask general questions because I want the person to tell us everything they saw. And if I ask leading questions, it's like it seems it could be a problem. So once the Crown does its questioning and its cross-examination, the defense asks for a dismissal, right? The defense says a motion for dismissal. It says that the Crown has not proven enough evidence to continue on with this. Let's just end it. Now, it's usually a formality, but if the Crown really did not a horrible job, the judge can say, you know what, you're right, we're done. And the court's over. It's directed verdict for the judge to withdraw the case from the jury and enter a verdict of not guilty, which means the judge can say, you know, this is a joke, you did nothing, you proved nothing, this is a waste of everyone's time. I am withdrawing the charge and I'm telling you, I'm saying I'm directing the verdict to not guilty. Defense goes home. And when the defense goes home, you can't be charged for that crime again. So it's called double jeopardy, which means once there's a court trial and once there's a decision, it's over, right? So Thomas can go to court for murder. If he's acquitted, he can go outside and say, hey, by the way, I murdered that person. I loved it. You can't do anything about it because he's been acquitted. It's been a decision that's been rendered and it's over. If it doesn't happen, and let's see, continue on, the defense gets to do the job. The defense gives its opening statement, and then the defense basically calls up witnesses, right? They do direct question, they do direct evidence gathering, direct questioning, and then the Crown does cross examination. If during cross examination on either side, there's a point that's being made, the opposite side, whether it's the defense or Crown, gets to ask for a rebuttal, which means they're able to sort of ask questions again to clear up something that they said in cross-examination, right? And I think you can't even, and then if that happens, you have something called a surrebuttal, which means that the opposite side can ask the question again to clear up anything that was brought up, right? So I asked what lead questions. So can't ask leading questions, can't have hearsay statements, given what hearsay evidence is. So you can only testify to what you see, hear, or experience. You cannot testify to what someone else told you. So if I said, Nathan, did you see that car run through the red light? He goes, yes, I did. But if Nathan goes, well, no, I didn't. Thomas told me car went through a red light. That's hearsay, right? I don't care. Like, you have to testify to your personal experience. You can't do it with what someone else tells you. You can give opinion statements about what a car looks like, but experts are the ones that give actual statements. Only expert statements are the ones that are valued. Your opinion statements don't matter, right? The car looked blue. Well, is it blue or blue gray or blue light blue gray or what kind of blue? An expert will have to determine the color of the car. Immaterial relevant questions. You can't just ask questions that don't have anything to do with what's going on, right? I can't say, hey, Thomas, so what'd you have for dinner last night? It's a relevant question. Okay, it's a murder trial. So you would say, maybe you would ask the judge that this is going to lead to someplace else, but if it doesn't, it's still a relevant question. You have to ask questions about what's going on. It's got to be a pattern, right? Yeah.
Yeah, so what if this is you trying to indirectly
Yeah, then I would say, someone's objection go, Your Honor, I need to establish where he had dinner. He claims to have dinner at this restaurant. I need to establish what he had for dinner, right? And I want to know what he's going to tell me because I know what's on the menu of that restaurant. I know what days of the menu, and I want to see if this person can tell me. So again, what did you have for dinner last night? Okay, so that's but just generally fishing or asking questions that don't have anything on the topic. Now, responsive answers. Sometimes the Crown or defense counsel will question a witness and receive a reply that does not really answer the question. It's called non-responsive. When this happens, the counsel may ask the judge to direct the witness to answer the question properly. So, I ask you a question, you don't answer it. I go, Your Honor, he's not answering the question. They're not answering the question. The judge goes, answer the question. Right? You can't just say, I don't know. You can't mumble. Right? If you do that, you're held in contempt of court, and then you're held until you give an answer. Right? Which means the judge can say, well, I'm going to put you in jail until you answer the question. Right? The evidence you can do is direct evidence, which is evidence that testimony that by a witness to provide the alleged fact. So Nate saw Ilian stab Mo with a rusty knife. That's direct evidence. Right? He saw it, do it. Circumstantial evidence is evidence, indirect evidence that leads to a reasonable inference of a defendant's guilt. So indirect evidence would be, I think Nate killed someone because we found blood stains in Nate's car. Nate has put on Instagram several pictures of Mo calling him a loser. Nate has been on we have texts of Nate talking about how much he can't stand him, right? And Helen testifies that when they were hanging out, Nate said, you know what, if I had a chance, I would kill Mo. None of that is direct, but it's so indirect. It's like, well, if all that stuff happened, it's reasonable to assume he probably killed him, right? There are lots of cases are circumstantial, right? Because do people see people murder people most of the time? Right? Do you guys know what happened at Don Mills, the shops at Don Mills yesterday?
Yes, sir.
Yeah, yesterday night. It was a shootout, right?
Wait, there was a shootout?
Yeah, cops and kids and like someone from 14 to 40 years old were shooting at each other, right? So now who shot whom and what? It's direct and circumstantial evidence. If someone's there and they're saying the cops said he shot at me, the person, well, did I shoot at you? Did you see me shoot at you? Right? But if I get evidence, well, you were there, you were sitting with a gun, you ran away, you're probably shot at somebody, even if I don't have direct like fingerprint or the weapon or those things that are far more direct. Yep.
But I'm sure they have surveillance cameras so they can see what
That would be direct evidence, right? But indirect evidence would be, or circumstantial would be, these are all the things that lead up to the event, right? So again, lots of people, you can be tried with circumstantial evidence. Like I never really saw Helen steal that fur coat, but I have all these other things around the issue that looks like she stole the fur coat. So therefore, it's reasonable to assume that she stole the fur coat, right? So direct evidence is always the best because you can put someone someplace, it's golden, but people have gone to jail for circumstantial evidence because everything kind of adds up, right? Motive, opportunity, what you said, your state of mind, where you were. Like Nate, where were you for those hours? I don't want to tell you. I was sleeping. Was anyone near you? No. Not really. So it's circumstantial evidence. Do a couple more for a break. Character evidence is like when you testify for someone's character, Helen goes, but I've known Nate for years and he's not the type of person to do that thing. He goes to church, he volunteers at a homeless shelter. He's not the thing. You have that there because that would dispel he's a murderer. You have a character evidence, right? Because again, you're trying to balance against circumstantial evidence that, look, it looks like he may have done it, but he's not the person to do that, right? Electronic surveillance is always the best because quite frankly, you can't dispute things you see, though people sometimes do that. Think about the whole thing we had when we saw your jury, when the guy said, no, he hit me, and then I broke my arm. The moment we saw the video evidence, people were like, what the hell is going on? Like, you saw that Messiah jury went to the guy shoved him. He goes, whoa, hey, he's pulling out his ID, then he gets shoved by the cop, and he goes, what? He goes, you see him say, what the hell? I'm a president of the Raptors. And the guy shoved him again. The guy shoves him back. The cop says, no, he hit me. He abused me. He spit at me. I'm like, no. Video evidence tells us he did the exact opposite, right? So that's hard to dispute because clearly you claimed he attacked you and injured you and you shoved him twice. The only reason why he shoved you once is because you shoved him twice and everyone broke it up. And there are people saying, no, that guy is the opposite thing. So electronic surveillance is an important thing. Wiretapping is intercepting the television communication. Bugging, recording a speaker's oral communication by using an electronic device. Those things require warrants, right? You can't just bug somebody. I think, and I'll pause this soon because we're going to go break soon. I think, though, when it comes to communication between two people, you can record a communication on one side. So if Nate and I are having a conversation and I record it, it can be evidence used against him because I'm part of the conversation and I can record any conversation I want. So you know what I'm saying? Like if I'm a cop and I wanted to bug somewhere to hear, I need a warrant. But if he and I are having a conversation and I choose to record the conversation and I turn it as evidence, I think Nate doesn't really have any, he doesn't have any right to privacy because in a conversation, you can't give that right to privacy, right? That makes sense, everybody?
Yeah.
Right? If I were his lawyer, no, I can't do that. If I were a priest, no. But, you know, sometimes people require something on their end for evidence, and that's legal, as long as you're not a police officer. Okay, I'm gonna pause this recording. Just a quick thing, so wiretapping can only, and bugging can only be used as evidence with a warrant. However, if there's an emergency situation that entails someone life or death, you can use evidence in wiretapping. So if I intercept a communication that there's going to be a bomb at Willowwood, and a police officer, and we arrest a person, I could use the wired evidence of capturing that as evidence because that person was doing something that was an imminent danger right away. If it was just me surveilling a criminal organization without a wiretap, and I'm just keeping tracks on them, or without a warrant, the wiretap would be illegal. Okay, so everyone's favorite thing, polygraph test. So lie detector tests, so they're not admissible in court for numerous reasons. One, they're not really 100% reliable. Second, I don't know if you can beat them or not. There are rumors that you could beat a polygraph test because what they do is that they're really just monitoring your responses to questions. And human beings tend to have certain key responses when lying.
Hold on.
Hmm?
But how do they make the machine so it can detect if you're?
It's your blood pressure. So they ask you a series of questions that you're truthful to. They ask you some questions to lie. Then they see how you react. So it's like, look, you seem to be stressed out here. So therefore, you're probably lying, right? And the people who read them and can tell whether or not you're lying or not. But I've always wondered if you're a sociopath and don't know right from wrong, then perhaps you could lie, right? Also, there's also a big situation is that it's also could be against your charter rights because you have the right not to testify against yourself. And if I put a polygraph test on you, you're testifying against yourself. Your body's telling is giving me information that you may not want to do. So if I go, Nate, put this on. Hey, you steal a cheesecake? No, but it says he's testifying against himself, right? So that's another reason that I think polygraph tests are like, look, it's not his choice to testify, right? He's literally we're just recording his responses. And but basically the idea is that the accuracy depends upon the examiner, so therefore it's not competent. If you have a crappy examiner, they may misinterpret the readings, so therefore it's not used. You can use it as a way of saying, I put on Regina, I asked her questions, and I think and she fails it, then I go, okay, maybe I will go after her as a prosecutor and try to find other evidence to prove her guilt. But I could never use the test as a way to establish guilt or innocence because if it's wrong and fallible, then I've already told the jury, oh, guess what? This person is guilty because they failed the test, right? It's not an episode of Maury Povich where we put something on somebody and they tell you if they've had a baby daddy or whatever nonsense. So also during trials, you have some kind of voir dire, which means it's just a little mini trial that sometimes you have with jurors. Jurors are excused, some of the admissibility of evidence. So sometimes if I have evidence that might be not admissible, and if the jury hears the evidence, it might change their positions on a case. I then ask for a voir dire, the jurors are removed, and then we have a trial on whether or not the evidence could be used. Okay, it's a very important thing because as much as you say to people, okay, here's evidence, ignore this evidence, and only focus on this evidence. Once evidence is out there, it's hard to change people's opinion. A good example. I'll use an old example. When O.J. Simpson went to trial, he put on the gloves, right? He put on the gloves in a way that it couldn't fit his hands. That's powerful evidence that might that people say, well, what about all the other evidence that he did it? Go, yeah, but that one image of the gloves not fitting might have had an impact on people, right? So you never want to give a jury evidence and ask them to forget it because it's hard, versus just only give them the evidence that they can focus on what to do. So after the case is after each side presents their argument, they summarize the case. They talk about what they think is going to happen. Now, some of the cases are also long. Judges, courts, lawyers will say, "Hey, so this is why the case we proved. Here's how the law supports us. You got to choose our side." After that happens, the judge gives a charge to the jury, which means the judge then tells the jury they have to go and make a decision. They tell them how the law applies before the case before them. So the judge is like, okay, so here's what the charge is. Here are the rules you have to follow. You can only follow the rules there. So again, I'm using the states as a good example, but the BITL is a good example of this, right? Some argue that what they did was they didn't charge the grand jury with the right thing to prosecute for. They said you can only charge those cops for this. So they did for that. So people say, well, did you mention second degree murder? Did you mention these other things? And some jurors said, if you told me I could have done that, I would have probably gone for a higher charge, right? So what the judge says to the jury is telling them, here are the rules that you have to play by. They're also warning them because if you do not follow those rules, the judges can't overturn your verdict, right? If I say, this is what first degree murder is, you can acquit. You have to find the person guilty if they've done these things. And let's say people say, well, I just decided I don't like it. I want the person to go free and I don't care. The judge could say, you're not applying the law. You're supposed to apply the law. I'm substituting my verdict for yours. Now, again, it doesn't really happen because most times juries just do what they're told, right? They understand that's the legal, like you're there, and the decision you're making is one based on law, right? You're not experts, but the judge says this is what you need to do to make sure that you make the right decision. So a verdict is, again, has to be unanimous. Everyone's got to agree to it. Let's say I get a verdict for Thomas and I say, it says he's not guilty. I can, as a counsel, say I want to poll the jury, which means I want to ask each jury how you voted. The idea is that I want, if I can get one of those juries to admit they didn't vote that way, they voted another way, it becomes a hung jury, which means that they cannot reach a unanimous verdict. It is a mistrial, and I start all over again. That advantage goes to the Crown or to the defense, because then they could say, well, now I know the exact type of case Crown's going to do. I know how to defend against it, right? And you can have appeals, but appeals have to be based on mistaken law, right? Which means that there was a mistake in interpreting the law. It has to be a reason for appeal. You just can't appeal because you're saying, I don't like the decision. There has to be a reason or rationale. This is just a little chart that kind of tells you how each of the things, how the juries break down. This is what happens when you go through the system. When you call for appeal, there's an appellate, there's a party that files for the appeal, and the respondent is the response to the appeal. But again, there has to be a reason. Is there mistaken law? Was there a misinterpretation? Was there bias in the decision? Once you determine those things, then you can go forward to say trial should be redone or the verdict should be struck down. I think we're done. The important thing is that once a decision is made, it sticks. So if you are guilty, you are guilty, right? Let's say there's no appeal, you're guilty for that crime. It becomes part of your record. If you are innocent, then it's over. And you cannot be charged for the same crime twice, right? It's called double jeopardy. You cannot be charged or punished for the same crime twice. So again, I could murder someone, become acquitted, and then literally go out on the street and said, I murdered that person. Okay, now it's probably not good for my civil court case, because civil court, they could sue me. It's a less of a burden, and if I just admit to murdering somebody, then yeah, I'm in trouble. But criminally, you can't come after me. Also, on top of that, if I was found guilty and I served my sentence and I got free, and people say, wait a minute, he did actually worse. Let's charge him again for that crime. No, I've served my sentence for that crime, and therefore you can't bother me. Okay, so either one is an example of our court system. Okay, there's a lot of talking. Are there any questions about this specific system and how it operates? Okay, my advice, don't ever get caught in it.